Legal and Privacy Brief for July 30, 2026. The FTC, the Federal Trade Commission, sued Hims & Hers for sharing patient health information with advertising platforms despite privacy promises. Epic and CDT urged the FCC to reconsider invasive Know Your Customer requirements that would mandate collection of government ID from all phone subscribers. Trump asked the Supreme Court to overturn the $83.3 million Jean Carroll defamation verdict on presidential immunity grounds. Here's the full breakdown of today's top legal and privacy stories. Next section, Enforcement Actions. FTC, the Federal Trade Commission, files lawsuit against Hims & Hers for privacy violations summary. The Federal Trade Commission, joined by Utah and California, sued telehealth provider Hims & Hers for sharing sensitive patient health information with third-party advertising platforms, including Snap and Meta, while simultaneously promising customers their medical records would only be accessed by healthcare providers. The company shared customer lists and embedded third-party tracking technologies that disclosed website visitor actions related to sensitive conditions, including sexual health and mental health treatment. The FTC alleges violations of the FTC Act's prohibition on unfair and deceptive practices. Compliance action. Review all third-party tracking pixels and advertising integrations on telehealth and healthcare websites. Verify privacy policies accurately describe data sharing practices, particularly for HIPAA, the Health Insurance Portability and Accountability Act, exempt direct-to-consumer health services that fall under FTC jurisdiction instead of HIPAA. Sources: The Record. Costco settles misleading email class action for $14 million summary. Costco agreed to a $14 million class action settlement over allegations it sent misleading sales emails to consumers. The settlement provides compensation to affected consumers who received the promotional communications. Source: Top Class Actions. IQ Credit Union settles overdraft fee class action for $750,000 summary. IQ Credit Union agreed to a $750,000 class action settlement over allegations of unfair overdraft and NSF fees. No claim form is required for affected customers to receive compensation. Source: Top Class Actions. Next section, Litigation Updates. Trump petitions Supreme Court to overturn $83.3 million Carroll defamation verdict summary. President Trump asked the Supreme Court to overturn the $83.3 million jury award to journalist Jean Carroll in her defamation case, arguing the verdict wrongly eviscerates presidential immunity. Trump's lawyers contend the Second Circuit failed to determine whether his statements were entitled to immunity after the Supreme Court's 2024 ruling indicated most presidential public communications likely fall within immunity protection. The federal government separately filed requesting the court decide whether then-Attorney General Bondi's request to recertify Trump statements as official acts should have been granted. This petition is separate from Trump's earlier appeal of a $5 million judgment in Carroll's sexual abuse case, which the court denied in June 2026. Sources: Scadu S-Blog, Scadu S-Blog. Lululemon faces class action over retained tariff windfall summary. A proposed class action alleges Lululemon unlawfully retained millions of dollars in tariff-related price increases paid by consumers after the Supreme Court struck down the underlying tariffs. Plaintiffs claim customers are entitled to refunds for the tariff costs that were passed through but later invalidated. Source: Top Class Actions. Federal judge rules DOJ. Department of Justice S. Portland police investigation undermined by AG's public statement summary. Federal Judge Michael Simon ruled the DOJ's attempt to leverage a 2013 Portland Police Bureau consent decree over excessive force was conducted in bad faith after Assistant Attorney General Harmeet Dillon publicly announced a full investigation via social media before proper legal process. The DOJ cited a settlement paragraph addressing treatment of people with mental illness to demand thousands of documents related to the arrest of conservative influencer Nick Sorter during anti-ICE protests, despite the settlement containing no provisions about speech suppression. The court rejected the government's motion. Source: TechDirt. Next section, Regulatory Guidance. Former FCC officials condemn ABC license review as First Amendment violation summary. A bipartisan coalition of former FCC officials filed comments blasting Chairman Brendan Carr's early ownership review of ABC's 8 broadcast licenses as a grave violation of both the Communications Act and the Constitution. The officials argued the review is a pretense to punish ABC and Disney for speech critical of the Trump administration, including the View's hosting of Democratic candidates and ABC journalism. Former Chairman Mark Fowler stated, "Just because the FCC issues licenses doesn't make it the speech police." The officials urged the FCC to terminate its investigations and rescind its news distortion policy that Carr has used to threaten journalistic freedom. Compliance action. Broadcasters should document compliance with equal time rules, but recognize courts have consistently exempted news and talk programming since 2002. Maintain records showing good faith application of FCC rules to both parties. Source: TechDirt. Next section, privacy developments. Epic and CDT oppose FCC Know Your Customer expansion summary. Epic and the Center for Democracy and Technology filed comments urging the FCC to reconsider or significantly narrow proposed rules expanding Know Your Customer requirements for voice service providers. The proposal would mandate collection and 4-year retention of name, physical address, government-issued ID number, and alternate phone number for all new and renewing phone customers. Epic and CDT argued the requirements would severely harm anonymous access to phones, burden freedom of expression, put subscribers at risk of data breaches, and cut off vulnerable populations lacking government ID from essential communications services. The organizations noted most robocalls originate overseas, and the domestic data collection would not affect foreign actors, making the privacy harms unjustified by unclear benefits. Compliance action. Voice service providers should monitor this rulemaking and prepare comments if the proposal advances. Document current identity verification practices and assess impacts of expanded requirements on customer base, particularly vulnerable populations. Source: Epic News. GDPR, the General Data Protection Regulation, complaint filed against DICT. CC for 1,741 partner consent request summary. Privacy advocacy organization NOIB filed a GDPR complaint with the Austrian Data Protection Authority against online dictionary DICT. CC for requesting user consent to share personal data with 1,741 partner companies via a single click. Reading all partner privacy policies would require approximately 170 hours, making informed consent impossible under GDPR requirements that consent be freely given, informed, specific, and unambiguous. The complaint requests the DPA, Data Protection Authority, order deletion of unlawfully processed data, notification to all data recipients, and fines to prevent future violations. NOIB noted this practice is common across websites relying on online advertising, 8 years after GDPR took effect. Compliance action. EU-facing websites should audit consent management platforms and partner lists. Limit data sharing partnerships to those users can reasonably evaluate. Consider consent models that allow granular selection rather than all-or-nothing consent to hundreds of vendors. Source: NIBE. Flock Alper expansion increases false positive rate summary. Expansion of Flock Safety's automated license plate reader network has led to increased false positives, including incidents where Range Rover journalist Joel Felder was detained by Minneapolis police after Flock cameras misread New Jersey plates with smaller digits. Officers tracked the vehicle for days based on false stolen vehicle alerts. A separate incident involved Texas police using Flock to track someone potentially seeking an abortion after leaving state. Flock has made no effort to limit abusive access until forced by customers or outside pressure. Compliance action. Law enforcement agencies using Alper systems should implement manual verification procedures before high-risk stops. Agencies should audit searches for evidence of tracking across state lines for constitutionally protected activities. Sources: TechDirt. Next section, policy changes. Legal experts propose limiting Supreme Court's judicial review power summary. Legal scholars are proposing reforms to limit Supreme Court authority following a contentious term, including a consensus rule requiring 7-2, 8-1, or 9-0 supermajority votes before the court can strike down federal laws. Harvard law professor Nicholas Bowie testified before the House subcommittee calling for an end to judicial supremacy and proposing Congress include specific judicial review standards in legislation. The proposals represent alternatives to court expansion or term limits, though implementation would likely require constitutional amendment or the court overruling foundational precedent from Marbury v. Madison. Source: Scadu S. blog. China proposes civil lawsuit framework for foreign nationals summary. China drafted legislation allowing foreign individuals and organizations to be sued for any illegal act that harms Chinese national or public interests, with no enumerated list of qualifying conduct. The open-ended standard gives Chinese courts discretion to define illegality, harm, and national interest without the filters and notice requirements protecting domestic defendants. Foreign defendants would face broader exposure with fewer procedural protections than Chinese citizens under the asymmetric framework. Compliance action. U.S. companies operating in or with connections to China should assess exposure under broad national interest standard, document compliance with Chinese law, and consider insurance or indemnification for legal defense costs. Source: Lawfare. Trump administration expands radical left terrorism prosecutions under NSPM 7 summary. Presidential National Security Memorandum NSPM 7, issued September 2025 without congressional approval, authorizes preemptive law enforcement against Americans based on political ideology rather than planned violence. The memo identifies anti-Christian, anti-capitalism, or anti-American views as terrorism indicators and empowers multi-agency task forces to investigate perceived threats from the political left. The DOJ has used this framework to convict activists and impose decades-long prison sentences. Secretary of State Marco Rubio's Ministerial on Political Terrorism drew 65 countries to coordinate international action against Antifa-aligned networks. Compliance action. Nonprofit organizations engaged in activism should review IRS and FBI joint investigation risks under NSPM 7. Document lawful advocacy activities and consult counsel regarding First Amendment protections before participating in protests. Source: TechDirt. Next section, compliance takeaways. Telehealth privacy, audit all third-party tracking pixels on healthcare websites. FTC jurisdiction extends to HIPAA-exempt direct-to-consumer health services, requiring truthful privacy policies that accurately describe advertising platform data sharing. FCC Know Your Customer. Monitor the FCC's proposed expansion of identity verification requirements for voice services. Prepare to submit comments if your organization provides telecommunications services or represents affected populations. GDPR consent management. EU-facing websites should limit consent requests to vendors users can reasonably evaluate. Consent to 1,000-plus partners via single click does not meet GDPR, informed consent standard, and exposes organizations to enforcement. ALPR systems. Law enforcement agencies should implement verification procedures before stops based solely on automated plate readers. Document policies preventing use of ALPR for tracking constitutionally protected interstate travel. Presidential immunity litigation. Organizations subject to lawsuits by current or former presidents should monitor Supreme Court developments on presidential immunity scope, particularly regarding statements made in official versus personal capacity. That concludes today's legal and privacy brief. From Carolina Clear Tech, for informational purposes only, not legal advice.